Friday, day 5 of the Epstein unsealing crisis. The consequences just started showing up. 3 sitting cabinet officials hired crisis attorneys this morning, before the documents even dropped. 5 days. Here's what's already changed. DOJ opened preliminary inquiry into judicial tampering allegations. 12 current officials placed personal holdings into emergency blind trusts. White House counsel's office conducting internal review of entire administration. But that's just the surface. Congressional staff are quietly updating resumes and reaching out to headhunters. The document isn't the bomb, it's the tripwire for what comes next. This isn't about Epstein's crimes anymore. I'm going to show you who this actually hits. Not headlines. Real people, real careers, real constitutional crisis. 3 groups getting crushed. 2 precedents that change judicial power forever. 1 question that determines if this government survives. By the end, you'll see why this matters, even if you don't care about Epstein or redacted files. Let me break it down. What's happened in 5 days? Immediate casualties, Patel and Bondi, both hired separate legal teams. Neither made public statement. White House distancing language already appearing in press briefings. 23 administration officials, retained personal counsel independent of White House counsel's office. Federal judiciary, emergency judicial conference call scheduled, first time in 17 years outside scheduled sessions. Market and industry reaction. Legal recruitment firms report 670% increase in inquiries from government officials. Crisis PR firms fully booked through August. Political prediction markets show 34-point swing in administration stability ratings. Policy and regulatory response. House Oversight announced emergency hearing for June 12, subpoenas being drafted. Senate Judiciary, bipartisan working group formed to assess judicial overreach versus executive accountability. Federal Judges Association issued statement supporting Hanks's authority, unprecedented intervention. That's measurable fallout in 120 hours. Now let me show you the deeper impacts nobody's connecting yet. Fast recap. Day 1, Monday. Judge Hanks orders review of sealed Epstein files for potential unsealing, citing public interest in executive branch conduct. Day 2, Tuesday. FBI Director Patel files emergency motion claiming national security exemption. AG Bondi files supporting brief. Day 3, Wednesday, Hanks rejects both motions, orders 48-hour compliance, appeals filed to 4th Circuit. Day 4, Thursday, 4th Circuit denies emergency stay in 6-hour turnaround, Supreme Court declines to intervene. Day 5, today, Hanks orders unsealing with minimal redactions by 5 p.m. today. DOJ opens tampering investigation. That's the sequence. Now, who this affects beyond Patel, Bondi, and one judge's order? Career DOJ attorney who handled the original sealing, affected. Congressional staffer who thought they had secure job, affected. Federal judge making future ruling about executive privilege, affected. Separation of powers doctrine itself, permanently affected. This isn't political scandal. This is the constitutional operating system being stress tested in real time. Subscribe. This analysis goes deeper than headlines. Group 1, current administration officials not named in files. Who they are: cabinet members, senior White House staff, political appointees across executive branch. How many? Approximately 1,200 Senate-confirmed appointees, 3,000 plus senior political staff. Specific impact. Association damage. Even officials with 0 Epstein connection now defending themselves, "I wasn't involved," sounds defensive. Confirmation liability. Future appointees will face Epstein-era scrutiny questions in hearings indefinitely. Career ceiling. Private sector increasingly unwilling to hire from tainted administration, reputation risk for companies. Timeline. Impact hitting now. Job offers being withdrawn. Board seats rescinded. Real example, Deputy Secretary at HHS, appointed 2025. Exemplary record, never met Epstein. Their situation before? Respected technocrat, on track for hospital system CEO role after government service. Their situation now? 3 job interviews canceled this week, told we need to wait for dust to settle. Their situation in 30 days? Likely resigns from administration to salvage private sector prospects before association hardens. Group 2, federal prosecutors who handled original Epstein case. Who they are: career DOJ attorneys who negotiated 28 plea deal, managed evidence, made sealing decisions. How many? 14 identified prosecutors directly involved, 40 plus supporting staff. Specific impact: career destruction, 18 years of work now scrutinized as potential obstruction or conspiracy. Legal jeopardy: if Hanks's unsealing reveals prosecutorial misconduct, personal criminal exposure possible. Institutional betrayal: DOJ can't protect them. Opening investigation means agency abandons career staff to save itself. Why this group didn't see it coming? Assumed decisions made under lawful supervision in 2008 were protected. Real example, Assistant U.S. Attorney who drafted sealing motion in 2008 under supervisor direction, now GS-15 in different district. 18 years unblemished service, followed orders from U.S. Attorney appointed by President. Now, retained personal counsel under internal DOJ review. Might lose pension if fired for misconduct. Group 3, federal judges who ruled on Epstein matters previously. Who they are: district and appellate judges who handled Epstein case, appeals, or related civil matters over 18 years. How many? 8 federal judges with direct Epstein case involvement. Why they're exposed: Hanks's unsealing might reveal what previous judges saw but kept sealed, raises questions about their judgment or complicity. Specific impact: impeachment risk. If sealed documents show judges ignored obvious red flags, House could initiate impeachment proceedings. Legacy destruction. Judges serve for life, but reputations can die in afternoon when files drop. This group thought they were safe because judicial immunity protects decisions made on the bench. They weren't. Immunity protects from civil liability, not impeachment or historical judgment. Real example, senior district judge who approved 28 plea agreement and sealing. Now 71, semi-retired, respected career. If documents show prosecution presented misleading information and judge didn't question it, legacy becomes judge who let Epstein off. See who this hits? Like this breakdown. Change 1, judicial authority over executive privilege claims. What it was before. Executive branch could claim privilege or national security to seal documents. Courts generally deferred absent extraordinary showing. What it is now. Single district judge can override FBI Director and Attorney General on sealing decisions if public interest standard met. Why it won't go back. Fourth Circuit and Supreme Court both declined to intervene. That's precedential approval by silence. Concrete example. Future case. Executive agency claims national security to seal embarrassing, but not actually sensitive, documents. Before, court likely defers to executive expertise. After, court can cite Hanks precedent. Public interest in executive accountability outweighs claimed privilege. Change 2, speed of appellate review in executive privilege cases. What was assumed? Emergency appeals take weeks minimum. System gives executive branch time to negotiate. What's now proven? Fourth Circuit ruled in 6 hours. Supreme Court declined intervention in 3 hours. Total, 9 hours from appeal to final rejection. Who gained power? District judges. Their orders stick immediately. Transparency advocates can't run out clock on appeals. Who lost power? Executive branch can't delay through procedural tactics. Appellate judges trying to give careful consideration. Concrete example. Future judge orders unsealing. Executive branch has maybe 24 hours before order executes, not weeks. Before, time to negotiate redactions, work out compromise. After, comply immediately or face contempt. Appeals won't save you. Change 3. Personal legal liability for government service. What wasn't possible before? Career officials assumed following lawful orders protected them from future liability. What's now established? Decisions made under supervision 18 years ago can result in personal legal jeopardy if political winds shift. Next time, career official asked to make controversial decision must assume it could be criminally reviewed decades later under different administration. Concrete example. DOJ attorney asked to make aggressive prosecution decision. Before, I followed policy and supervisor direction. I'm protected. After, this could be criminally investigated in 20 years if political climate changes. I need personal legal insurance. These aren't temporary overreactions. These are permanent changes to executive branch function and judicial power. The unsealing isn't the impact. The precedents Hanks created getting there are the impact. Secondary consequences. Area 1, government recruitment. Not directly involved, but affected because talented lawyers and executives now see government service as career liability. Decisions haunt you forever. Specific changes. Top law schools reporting 23% drop in students interested in DOJ honors program. Executive search firms say private sector candidates rejecting presidential appointments. Why it matters. Government gets lower quality talent pool. Private sector gets people who would have served. Area 2, federal document sealing standards. Connection that wasn't obvious. Hanks just made every sealed federal document potentially unsealable by any district judge claiming public interest. Impact. Agencies scrambling to review millions of sealed documents for potential embarrassment. Legitimate law enforcement investigations might be compromised. Witnesses won't cooperate if they think sealing promises are temporary. Example, confidential informant in ongoing case. Before Hanks, sealed meant protected. After Hanks, some future judge might unseal for public interest. Area 3, judicial confirmation process. Nobody saw this coming. Senate will now ask every judicial nominee, under what circumstances would you override executive privilege claims? But nominees who say frequently won't get confirmed. Executive branch senators oppose. Nominees who say rarely won't get confirmed. Transparency senators oppose. Example, next Supreme Court vacancy. Nominee asked about Hanks' decision. Any answer loses votes. Supporting Hanks, executive power senators vote no. Opposing Hanks, transparency senators vote no. Judicial confirmations just got harder. The ripples spread outward in waves. Hanks unseals Epstein Files, which affects government recruitment, which affects document sealing practices, which affects judicial confirmations, which affects Supreme Court composition. 4 degrees of separation from one judge's order about documents from 2008. This reaches further than you thought. Stay with me. How industries are adapting. Federal agencies. Immediate changes implemented. Emergency review of all sealed documents from past 20 years for Hanks risk. New protocol requiring Inspector General approval before claiming national security sealing. Right arrow. Memo to all agencies. Assume sealed documents eventually become public. Why they moved fast? Fear that Hanks precedent means nothing stays sealed permanently. Every agency has embarrassing files. Example agency. Announced within 36 hours, all confidential informant agreements now include sealing not guaranteed disclaimer. Result, informant cooperation dropping. People won't risk exposure. Crisis management industry, different approach. Flooding market with reputation protection for government officials, insurance, and services. Their calculation, Government service now carries permanent reputation risk. Create products to monetize that fear. Whether it will work? Short term, yes. Officials panicking and buying coverage. Long term? Can't actually protect reputation if criminal conduct revealed. Just delays reckoning. The pattern. Everyone's assuming sealed documents eventually become public and planning accordingly. Nobody's addressing root question. Can government function if officials assume all internal deliberations eventually become public? That gap is the next problem. Executive branch needs some confidentiality to function. Candid advice, sensitive deliberations, protection for sources. If Hank's precedent means nothing stays sealed when public interest exists, government loses ability to self-reflect honestly. Compliance theater, reviewing old files, disclaimers, doesn't solve fundamental tension between transparency and effective governance. Missing angle 1. Hanks might have destroyed witness cooperation programs. Everyone's focused on Epstein Files unsealing. Nobody's noticing federal witness protection and confidential informant programs just became unworkable. Why it matters. If witnesses and informants can't trust sealed promises, they won't cooperate. Major investigations collapse. Example, organized crime informant considering cooperation. Before Hanks, testimony sealed, your identity protected. After Hanks? Well, sealed unless some future judge decides public interest requires unsealing. Informant. No thanks, I'll take my chances. Missing angle 2. Foreign intelligence sharing quietly stopped while DOJ panics. Five Eyes intelligence partners are halting sensitive sharing with U.S. How? If U.S. judge can unseal documents claiming public interest, allied intelligence in those documents gets exposed. Nobody's reporting this because classified, but diplomatic sources confirm allies reviewing intelligence sharing protocols. Impact. U.S. might lose intelligence access because judicial system isn't predictable enough for allies to trust. Missing angle 3, the real question. The debate is, did Hanks have authority to unseal? The actual question is, should lifetime appointed judges make political accountability decisions that elected branches won't make? If you answer the deep question, Hanks did Congress's job, unsealing documents Congress should have investigated. Example, Congress could have held Epstein hearings anytime in 18 years. Didn't. One unelected judge did what 535 elected officials wouldn't. That's either heroic or anti-democratic, depending on your view of judicial power. These angles matter because they show unsealing might destroy government effectiveness while pursuing transparency. Like if you're seeing the bigger picture now, how this could play out. Scenario A, judicial transparency revolution. What happens? Hank's precedent gets embraced. District judges nationwide start unsealing old documents claiming public interest. Massive transparency wave. Decades of sealed government misconduct exposed. Requirements. Other judges follow Hanks's lead. Appellate courts affirm. Congress doesn't pass legislation limiting judicial unsealing authority. Probability, 20%. Why? Most judges are institutionally cautious, won't want to provoke constitutional crisis. Who wins? Transparency advocates, media, endless stories, citizens, government accountability. Who loses? Executive branch effectiveness, loses confidentiality needed to function. Whistleblowers and informants, cooperation collapses. Intelligence sharing, allies won't trust U.S. sealing. Scenario B, legislative course correction. What happens? Congress passes bipartisan bill clarifying judicial authority over sealed documents, establishes standards preventing future Hanks situations. System stabilizes with new rules. Requirements. Both parties see benefit in limiting judicial power over executive privilege. Bill passes before another judge copies Hanks. Probability, 50%. Why? Historical pattern. When courts go too far, Congress reasserts authority. Who wins? Congressional oversight gets proper role back. Executive branch, predictable rules. Judicial legitimacy, conflict resolved politically, not judicially. Who loses? Hanks personally. Precedent gets legislatively overruled. Radical transparency advocates won't get unlimited unsealing. Scenario C, constitutional crisis escalation. What happens? Documents drop at 5 p.m. today, reveal massive misconduct. Multiple cabinet officials indicted. Administration refuses to comply with next Hanks order. Judicial executive confrontation reaches constitutional breaking point. Requirements. Files contain crimes serious enough to justify prosecution. Administration decides fighting courts is politically viable. Hanks doesn't back down. Probability, 30%. Why? If files are bad enough, administration has nothing to lose by fighting, already destroyed politically. Who wins? Nobody's constitutional crisis damages all institutions. Who loses? Rule of law if executive defies courts. Judicial authority if courts back down. Public trust, government paralysis. Current trajectory suggests scenario B most likely, but it depends entirely on what's in the documents when they drop at 5 p.m. today. If files show minor embarrassment, scenario B. If files show felonies, scenario C becomes likely. Subscribe. I'll track which scenario unfolds. Practical preparation. If you're a current government official, expect media scrutiny of any past Epstein proximity, however tangential, next 72 hours. Congressional subpoenas if your name appears anywhere in files next 30 days. Actions. Retain personal legal counsel now before you know if you're named. White House counsel represents office, not you personally. Review your own records, emails, calendars, travel from 2000 to 2019 for any Epstein intersection, however innocent. Don't assume being unnamed protects you. Association with named officials creates exposure. If you're considering government service, expect enhanced background checks, including financial and association reviews going back decades. Senate confirmation questions about any sealed documents you handled. Actions. Seriously evaluate whether career risk is worth service precedent. Now, as your decisions might be criminally reviewed 20 years later. Build financial cushion for legal defense costs. Assume you'll need personal attorney during service. Don't assume institutional protection exists. Agencies abandon staff to save themselves. Everyone, regardless of government connection. Constitutional tensions between branches are highest since Watergate's. System instability affects everything from markets to law enforcement effectiveness. What to watch? Document drop content at 5 p.m. today determines scenario B versus C. Congressional response next week signals whether legislative fix coming. Foreign intelligence sharing patterns, leading indicator of allied trust collapse. Timeline, reassess Monday after weekend news cycle digests documents. If administration doesn't attack Hanks over weekend, scenario B likely. If administration attacks judicial legitimacy, scenario C accelerating. Next phase, short term, next 72 hours. Documents drop at 5 p.m. today. Media frenzy through weekend. By Monday morning, either careers end or much ado about nothing. Key dates. Today, 5 p.m., documents release. Sunday talk shows. Administration officials either defend or resign. Monday, 9 a.m., markets react, showing whether investors think government stable. These determine whether scenario B, resolution, or scenario C, crisis, unfolds. Medium term, 30 to 90 days. Congressional hearings begin. Criminal referrals made or not made. Either legislative fix passes or system adapts through practice. Watch for criminal indictments from DOJ's tampering investigation shows how serious misconduct was. Bipartisan legislation introduced shows Congress taking power back from courts. Judicial conference statement on Hank's precedent shows whether other judges will follow. Long-term, 6 to 12 months. Either new sealing standards codified or every sealed document from past 30 years becomes potentially unsealable, depending on which scenario wins. By December 2026, we'll know whether Hank's precedent becomes standard or outlier, whether executive-judicial relationship fundamentally changed, whether government service became too risky for talented people. The through line: Epstein's crimes aren't the story anymore. The story is whether judicial power can substitute for congressional oversight when elected officials won't do their jobs. If one judge can force accountability that Congress avoided for 18 years, we're watching the separation of powers doctrine being rewritten, not through constitutional amendment, through one district judge in one case saying enough. I'll keep tracking document contents, congressional response, and judicial community reaction as this develops. We'll know by Monday if this is transparency triumph or constitutional crisis.